Well, good afternoon, everybody. My name is Kent Lassman. I'm the president at the Competitive Enterprise Institute, and this afternoon, June 6th, we have a wonderful program lined up for you to talk a little bit about the Clean Water Act and a major court case that was handed down less than 2 weeks ago from the Supreme Court. I'll be joined today by my colleague Daren Bakst and Charles Yates, an attorney with the Pacific Legal Foundation, a public interest law firm that handled this case for more than a decade. It's a tremendous testament to their will to see things through in order to vindicate property rights. Of course, what we're talking about is the Clean Water Act. Sometimes the principle at issue is referred to as WOTUS, or the Waters of the United States Act, which is a provision of the Clean Water Act, because when you have regulation about water, you need to talk about and define and understand which waters, what constitutes waters. How do we know what is water and what is not? These are the difficult things that the EPA and the Corps of Engineers struggled with for years and years and years, holding back property owners from developing their land, living their life, and going on with the things that most of us take for granted. Chantell and Mike Sackett were the principals in this case, titled Sackett v. EPA, came down May 25, and I am excited to learn more about what the court actually found, what's at issue, what it might mean going forward. Before we get there, I want to remind our entire audience that throughout this hour, we'll be taking questions. So you can send questions via email at events@cei.org, or use the Q&A function at the bottom of your screen. Once we get through some preliminaries about what was happening, what's at issue, what was found by the court, we'll try to get all of you involved in the conversation as much as possible. Finally, I'd remind you that at the end of the hour, I'm going to ask one small favor. There's more than 150 people joining us for this live program, and it will soon be online at our website. But before we get there, we're always thinking about how to make this better. And so at the end of the program, we have a very short 3 or 4 question survey to help us bring better programming to you in the future. Okay, I think that's all of my administrative notes. I want to dive in here and turn to my colleague, Daren Bakst, to tell us a little bit about what is at issue and why is it so hard to understand what water is for a government agency. Why did we have to have this case dragged through the court system for so long?
Well, thanks, Ken. Over the last 20 years or so, the Supreme Court, twice they struck down the EPA and Corps' overreach. And that's before the recent Sackett opinion. So it's important to kind of look at some of the previous cases. So in a 2001 case called Solid Waste Agency in Northern Cook County versus Corps of Engineers, which is often referred to as the Swain case, the court was trying to figure out whether non-navigable, isolated, intrastate waters can be regulated under the Clean Water Act. So just think about that. If the court could regulate these intrastate waters, and there's not much they couldn't regulate, the court really could act like a local zoning board. In a 5-4 decision, the court held that the Clean Water Act doesn't authorize regulation of these waters. Thank goodness. 5 years later, in 2006, the court issued its opinion in Rapanos versus United States. And this is a big case that almost helped to resolve the WOTUS headache. And that would have been 17 years ago. I want to explain this case a bit because it's important to understanding the Sackett opinion. Justice Scalia, in his plurality opinion, was trying to create a workable way to figure out what waters were regulated. He was actually joined by 3 justices who are currently on the court now, Chief Justice Roberts and Justices Alito and Thomas. So Scalia stated that waters in the United States include only those relatively permanent standing or continuously flowing bodies of water, forming geographic features that are described in ordinary parlance as streams, oceans, rivers, and lakes. So basically what you would think of as bodies of water. So when I've written about the WOTUS issue, and just use the word waters, I've had editors want to change waters to bodies of water. But then I explained to them, the agencies are not just trying to regulate bodies of water by any common understanding. So it'd be inaccurate to save bodies of water. It goes way beyond that. So Scalia, with this definition of relatively permanent waters, was trying to make sure that the Clean Water Act did just cover bodies of water. So what else did the plurality say? Well, they said at a bare minimum, there must be the ordinary presence of water. This is very important language when it comes to figuring out whether the statute covers intermittent and ephemeral streams. So regarding ephemeral waters, these are so-called waters that can be dry land virtually every day of the year, but can hold water for a few days due to heavy precipitation. No reasonable person will look at some dry depression of land that could hold water and say, yeah, that's a body of water. Scalia clarified WOTUS does not include channels through which water flows intermittently or ephemerally. So what did Scalia say about wetlands? Only those wetlands with a continuous surface connection to bodies that are waters in the United States in their own right, so that there's no clear demarcation between waters and wetlands, are adjacent to such waters and covered by the Act. In other words, you can't tell where water ends and land begins. So all this sounds pretty good if you want to clarify, if you want clarity and workable definitions. But unfortunately, it was just a plurality opinion. Justice Kennedy concurred in the judgment, but created something called the significant nexus test, an unworkable ad hoc test requiring the Corps to establish on a case-by-case basis that wetlands adjacent to non-navigable tributaries significantly affect the chemical, physical, and biological integrity of other covered waters more readily understood as navigable. It's subjective, it's vague, and it can mean almost anything. And the EPA and Corps have taken advantage of this ever since. It's hard to overstate the problem that exists with vagueness when it comes to Clean Water Act. Property owners often don't know what waters are regulated, or even know that a property could even have Clean Water Act implications. It's easy to inadvertently violate the law. Judge Jane Kelly from the Eighth Circuit wrote the following about the unique nature of the Clean Water Act. Most laws do not require the hiring of expert consultants to determine if they even apply. Even Justice Kennedy wrote a decade after Rapanos, as Justice Alito has noted in an earlier case, the Clean Water Act's reach is notoriously unclear, and the consequences to landowners, even for inadvertent violations, can be crushing. With all this confusion, the EPA and Corps have not brought clarity, but have made things worse. And in recent years, there have been new WOTUS rules, stays, repeals, and times when one definition applies in some parts of the country and another definition applies in other parts of the country. 2015, the Obama administration issued its WOTUS rule. 2020, the Trump administration finalized its rule. Then in 2021, the Biden administration proposed its WOTUS rule. But something happened, though, before it could finalize the rule. The Supreme Court decided to hear the Sackett case, which was clearly going to provide at least some clarity to inform the EPA and Corps as to how to define WOTUS. Did the Biden administration wait until the Sackett opinion was published before finalizing its rule? No. Inexcusably, it finalized the rule even knowing that the Sackett opinion was only a few months away. To me, this showed yet again how the EPA and Corps couldn't be expected to properly handle the WOTUS issue. But now we have the Sackett opinion, and as will be explained, a lot has now changed for the better. Thanks.
Well, let's get to that, Charles. And let me say right at the top here, thank you for being with us. I know it's been a big couple weeks for your organization. You had a couple wins on the same day. That would be career making for most attorneys, but you've been involved with this Sackett case. This notoriously unclear, as Justice Alito wrote about the Nexus Standard and WOTUS rule. What are the facts? What was happening to the Sacketts, and why is it that the Supreme Court not only took this case again, which I think we'd like to hear about, but they heard the arguments on the very first day of the term?
Yes, that's a great question, Kent, and thank you to you and Daren and CEI for organizing this event on a very important issue. We at PLF really do appreciate it. So I think Daren provided a really excellent summary of everything that's gone wrong with the Clean Water Act, and particularly the way this vague significant nexus test has sort of allowed the agencies to usurp to themselves the power to act really as land use administrators at the federal level. What I want to do is I want to provide a little sort of factual background on the Sackett case and get into what the court actually held. and why this is so significant. So as Daren noted, the scope of the Clean Water Act has just been this ever expanding sort of ratcheting up of authority that the agencies have sort of brought upon themselves. So thinking about what was at issue in Sackett, right? So we're talking going back to 1972, EPA and the Army Corps were granted authority through the Clean Water Act to administer a permitting regime to regulate the discharge of pollutants into the navigable waters, which are defined as the waters of the United States. So that's sort of all well and good, right? What we have here, we have something that typically happens. We have Congress pass a statute, and then we have Congress place clear limitations on the agencies that administer that statute, right? They can only regulate to the extent that they've been granted power, the navigable waters of the United States. And that was what was at issue in Sackett. For the last 50 years, as Daren noted, the agencies have just ratcheted up their authority to regulate navigable waters to the point where it just blinks common sense, where they're regulating every wetland, ditch, puddle, pond in the entire country. So in Sackett, the court, squarely before the court, was this authority under the Clean Water Act to administer this permitting regime, and particularly as it applies to wetlands. Fortunately, in Sackett, a unanimous Supreme Court has rejected the significant nexus test, and a 5-justice majority adopted a test for federal authority under the Clean Water Act that respects congressional intent and places proper limits on the authority of the agencies. So going to the facts of
Can I pause you right there for just a moment? I want to make sure laymen like me are tracking. Did you just tell us the court has rejected the nexus test that came from Justice Kennedy, that was part of the plurality that only had, it made the fifth vote, if you will, for the plurality that Justice Scalia had written that did offer more clarity. So the test that got over the hump a decade ago has now been rejected. Is that what we're hearing?
That's correct. So in terms of the Rapanos decision, so unsurprisingly, kind of as Daren noted, the agencies sort of win, lose, or draw every time this issue goes to the Supreme Court. They've taken the opportunity to continue ratcheting up their authority. And the way they've done that for the past 15 years is to essentially treat the significant nexus test as a test. That's now been rejected. And what we have in its place is something that's much closer, very similar to that plurality opinion in Rapanos. So going to the facts of the Sackett case, sort of how we got here. So the Sacketts are the owners of a 0.63 acre lot near Priest Lake in the Idaho Panhandle. Now, that lot is residentially zoned. It has a mailbox address, contains a sewer hookup, and it's located in a built-out residential subdivision. So the Sacketts, their ordeal began in April of 2007, when after they went to the local authorities, obtained all of the necessary permits to build on that lot, and they began construction of a modest single-family home. Now, shortly after they broke ground, they began some preliminary earth-moving activities. Straight after they did that, officials from EPA and the Army Corps of Engineers entered the lot and directed that all work be stopped. Now, the Sacketts were absolutely blindsided. 6 months later, EPA issued a compliance order, which is essentially an order to comply with a directive from the government. And in that order, EPA asserted that the home lot, Sackett's lot, contains wetlands, which are regulated as navigable waters under the Clean Water Act. And it asserted that the Sacketts had violated the Clean Water Act by trying to build a home on that lot without first seeking federal permission. It also required them to engage in substantial remediation. And I think most importantly, it threatened them with tens of thousands of dollars per day in civil penalties should they fail to immediately comply with this dictate. So now, for 16 years, the Sacketts have been fighting this illegal land grab in court. And throughout that process, the agencies relied upon this significant nexus test that Daren referenced to argue that the Sackett's residential lot should be subject to federal authority as a navigable water. Now, as I noted, Supreme Court granted cert to address this issue of federal wetlands authority. It issued opinion on May 25th. And in that opinion, it unanimously rejected the significant nexus test. All 9 justices agreed that the significant nexus test is illegal. And all 9 justices unanimously held that the Sackett's lot is not subject to federal authority under any lawful interpretation of the statute. Now, we got a 5-justice majority led by Justice Alito, which set forth a clear standard for Clean Water Act authority, which is based on the Scalia-Rapanos plurality that Daren referenced in his opening remarks. Now, this test that the Supreme Court has set forth would limit regulation to waters, and waters understood in the conventional sense of the term. So relatively permanent or continuously flowing bodies of water like streams, oceans, rivers, lake, and the like. So like Daren mentioned, something that you and I could look at as laymen and say, hey, that's a water, the federal government may have an interest in regulating that. Now, as to the question of wetlands,
let me pause you there for a second. I want to hear about this wetlands because that's trickier, right? It doesn't look like a bay or a river. It's more difficult to discern maybe for the everyday experience. But I just want to understand and help our audience understand the limits to the authority and power of the court. So you describe, I think I heard you say, this couple, they wanted to build a home in a residential development where there were other homes being developed. There was already sewer put in, there was already roads. 16 years later, we find a unanimous ruling. 9 justices say, under no interpretation of the law was this regulation and behavior of the EPA or the Army Corps of Engineers legal. That is justice. They can move forward for their home. What sort of recompense do they get for being threatened, held at liable for fines, 16 years of no home? They had made an investment in the land and planned on building. They'd already broken ground. Is there anything to hold to account the EPA or the Army Corps for this bad behavior?
Unfortunately, there's no clear way to hold them to account. And that really goes to show sort of how insidious the growth of the federal administrative state has been, right? We see this in all contexts. It's not limited to something like the Clean Water Act, where relying on vague, overbroad standards, these federal agencies haul people into court, threaten them. And really, I mean, these federal agencies, they have the full power of the US Treasury backing them, right? They can go to court, they can litigate to the very end. And in their crosshair, they have individuals who may often have sort of limited means. And it just forces people into this lose-lose situation where essentially, I mean, the choice that you're given, the choice the Sacketts were given back in 2007 was comply with our order, go and seek a federal permit that could cost you hundreds of thousands of dollars, absolutely dwarf the value of the property just to build a single family home, or take us to court and we'll fight you to the very end to the Supreme Court twice. So that just, I think, goes to show that the broader issue, and we can get into that, I think, when we start talking about some of the broader implications of the case, because it's I think a really good example of how the growth of federal administrative agencies and federal power directly affects individuals and liberty.
Okay, so let me, I do want to get to that, what it means for property owners. Before we do, I cut you off being rude here in Washington. You're out there in Sacramento. Tell us, what does it mean for the wetlands? Because like I said, I cut you off, and then I want to turn to what this new ruling means for property owners.
Yes, so the wetlands question, it's a more difficult question because the Clean Water Act allows regulation in the waters of the United States. Now, as to this sort of wetlands question, the majority in Sackett, like the plurality in Rapanos, recognize that wetlands are by definition not waters, they're wet lands. So they're sort of presumptively outside the scope of the statute. But what the majority here did recognize is that there's often a sort of line drawing problem present when we talk about wetlands. Really, often on the boundary of a true water, say a river, lake, or the like, there's usually some ambiguity in drawing the line between where the water ends and land begins. So the majority recognize that with that in mind, some wetlands may be regulated, but importantly, they may only be regulated sort of incidentally to the regulation of the true waters, in that they must be inseparably bound up with and contain a continuous surface connection to that water, so that an ordinary person, again, a layman, could look and say, hey, I cannot tell where the water ends and the wetland begins. So in other words, the wetland must be indistinguishable. And this test is very, very significant because really it brings an end to the agency's approach of regulating virtually anything that's damp in the country under its wetlands authority, and brings some discipline to that, requiring that the agencies can't just come in and say, hey, this is wet. We can map some attenuated connection to a river that could be tens or hundreds of miles away. No, the agencies now must demonstrate that it's inseparably bound up with a true water.
Okay, so this goes to what Daren was telling us about the connection. It must be a surface connection, right? It can't be underwater channels. It can't be the water table. It has to be, I go out there and my boots get wet because I'm in a marsh. I'm genuinely in an estuary, that sort of thing.
That's right. If you were wading out through the marsh, you'd start swimming at a certain point, I think is
At a point you'd
the
start
sort of
swimming.
factual situation that the court has in mind.
So Daren, can you tell us, how does this new ruling, the ruling of May 2023, how does this affect property owners? What sort of clarity, what is different today? I understand the Sacketts are in a different position, but for the rest of us, the rest of the 330 million people in America, what did we gain from the ruling?
Well, I mean, we gained some clarity, which is really important. And when we're talking about bodies of waters like lakes and streams, that's something an ordinary person can actually understand. And if you can't tell where water ends and land begins, then maybe you have a wetlands, and that makes sense for property owners. You don't need to hire experts or get aerial photographs, which has been common practice for property owners. And it's a lot different. We're trying to figure out, does this property, which rarely is wet, has a significant nexus that like an ordinary person just simply not going to be able to figure out. One of the many problems that exists in the Sackett case is the agencies are trying to draw these very indirect and tenuous connections, so that if property A is connected to this water body Z, we can get there from B, C, D, and E. That somehow we can regulate A because there's this connection to Z. Well, I think this opinion ensures that doesn't happen anymore, that there's a more direct connection. So property owners will actually be able to figure out whether or not they can comply, and they'll know what waters are actually regulated, and they don't have to hire the experts, and they don't need to kind of figure out through aerial photographs, like I said, whether or not they're even covered under the law. And that's a real problem.
I want to get an understanding of how the High Court tackled this, Charles. As we referenced, it had been up and down a couple times through the federal appeals process. Before I get to that question, I have my first question from our audience, and a quick reminder to everyone, in case you missed it or I forgot to say, questions from the audience, you can use the Q&A function found at the bottom of the screen. You can email us at events@cei.org. I have all this stuff coming at me just to my left. We'll try to get as many people involved as possible. And if you're with the media and have a question, please identify yourself. And that way I can try to prioritize questions from reporters who are doing their best to understand what this means for Americans all over. But first, Tony is asking about a definition here in the case. Why is the definition of waters of the U.S. found in the Rivers and Harbors Act of 1899? That's a term that hasn't been referenced yet in our conversation. Charles, can you bring us up to speed on what appears to be nearly 125-year-old statute? We've talked a little bit about the Clean Water Act from 1972, but where does the Rivers and Harbors Act and the definitional question sort itself for us?
Yes, so in terms of the Rivers and Harbors Act, I think that's largely, it represents a proposition that this term, navigable waters or waters of the United States, is a term of art that has quite a long history in the federal code, going back to the Rivers and Harbors Act. And throughout those sort of pre-Clean Water Act statutes where that term was used, the term was used to refer to traditionally navigable waters, not these type of ephemeral streams, wetlands, and things of that nature. Now, the Rivers and Harbors Act kind of term of art, that's a little more relevant to the sort of broader Commerce Clause question that Justice Thomas approached in his concurrence. I think if you're talking about the waters of the United States, really that question, what is a water of the United States, it can kind of be divided into two kind of sub-questions. Sort of textual question, what is a water, which is what the majority here approached and what Scalia in the Rapanas plurality got to. So just looking at the text of the statute, what did Congress have in mind when it was talking about waters? There's a second question, which is when is a water of the United States, right? When is a water of the United States such that the federal government has the constitutional authority to be regulating it at all? And that really that the Rivers and Harbors Act question is a little more relevant to that sort of secondary question. And that's something that the majority here didn't really reach, but Justice Thomas in his concurrence wrote a very good opinion sort of analyzing that second question, the broader Commerce Clause question that's at play here.
And that brings us to some state federal questions I want to try to get to in the second half of our program. But first, a big picture question. I want to talk about how this affects our lives, regular people, in ways that they might not notice. Are we suddenly going to expect dirty water? We tend to think of environmental regulation as a protection against bad acts, health, safety things. Here we have the EPA and the Army Corps at issue, taking or infringing upon property rights. What does that mean for the health and safety, the quality of water that we should expect going forward? Maybe we'll start with Daren and then I'll turn to Charles.
It's an unfortunate assumption that that in order to protect our waters, the federal government has to be the one that actually provides the regulation of it. And this kind of does jump into a little bit of the state issue that we're going to talk about. Congress did not envision that the federal government was going to be have this huge overreach and try to regulate every water. It was the states that were going to play the lead when it comes to protecting our waters, at least as relates to the governmental role when it comes to protecting the water. What this basically opinion does is it might narrow the amount of federally regulated waters, depending on what the baseline is in terms of determining what are actually the regulated waters in the first place, which is actually a question. But let's say it does narrow the amount of waters that are covered. So then the states will play the role. They'll fill the gap. And it's really critical to remember that there's also private property and property owners that play a critical role as well in addressing solutions. And the reason why I should point out it's important for states to play this role is that they're closer to the issues. They're impacted by these water issues. It's better for the states to address the water issues than to have a federal one-size-fits-all approach.
And Charles, do you see broader regulatory implications here for the EPA or the Army Corps on how they're able to do their job, the job that Congress has asked of them to protect and nurture the ecosystems associated with waters in the United States?
So in terms of the regulatory implications, really all this decision does is it brings the agency's approach back in line with what Congress intended in 1972. So the agencies can still regulate within the waters of the United States as that term was understood by Congress when it passed the Clean Water Act. So that's all that it really does in that respect. But also, I think a point in terms of this question of water pollution and the implications of this decision in that respect, I think without getting too technical, I think there's an important point to note in terms of how the Clean Water Act operates. So I talk about it creates a permitting regime, prohibits the discharge of pollutants into the navigable waters. But there's two permitting regimes that are created by the Clean Water Act. There's a permitting regime under Section 402, which is known as the National Pollutant Discharge Elimination System. And that program, it applies to mobile pollutants, right? So something that when we're talking about water pollution, often what people have in their mind is like, oh, you've got a factory or some kind of industrial infrastructure and there's a pipe just piping out waste to a river, something like that. Mobile pollutants that are going to wash down and degrade water quality. There's also an additional regime, and this was what it was issued in Sackett. This is under Section 404, which is EPA and the Army Corps can also, or the Army Corps specifically, administers a dredge and fill permit program, right? And they conceptualize what is a pollutant and what is a discharge incredibly broadly. So under this dredge and fill program, we're talking about the discharge of material that's going to stay in place. And this is generally what we're talking about when we're speaking about wetlands. We're talking about what the Sacketts did, putting gravel on a residential lot. So I think it's important to note that this is the incredibly broad way the statute has been applied. it goes well beyond sort of traditional notions of water pollution, to the point where they consider their dredge and fill discretion so broad that, I mean, we had a case several years ago, just goes to show a good example of how they've been going about this. A farmer, he wanted to plant a winter wheat crop, so he plowed a field in order to plant that crop. Now, the agencies came in and took the position that the action of the plow running across the field, so they asserted that the field contained wetlands, which are waters of the United States in their view, and they claimed that the action of the plow going across the field, kicking up dirt and redepositing it. So by kicking up the dirt and redepositing it, the dirt was a pollutant, so it was discharging a pollutant into the waters of the United States. So I think when we're talking about this water pollution question, it's important to note just the breadth of authority that they've claimed, and the fact that really often what we're talking about, particularly when we're talking about wetlands, are really just quintessentially ordinary land use activities that I think no rational person would think of when they're talking about water pollution. So things like farmers plowing fields, the Sacketts depositing gravel on a residential lot. So I think that's an important note on this question, just how broad the agencies have asserted their authority.
So moving stone or dirt from point A to B, and the way a plow works is it comes in at an angle and it lifts and turns something over. That's a pollutant. We're not talking about trash bags or dumpsters or standpipes out of a factory right into a river. All of this is what the Army Corps was looking for as far as prohibiting permits for any sort of construction.
That's correct.
Okay, we have our first question from a reporter, and I see that I've got a long list of questions, so we'll try to move through these quickly to get us back on top of things. Todd Neely is with DTN, and he asks for either of you, does the court's ruling essentially require a rewrite of the waters of the U.S. rule? We heard at the top of the program that the EPA issued a brand new rule after argument, but before the ruling. Is that rule going to have to go back to the beginning? Are they going to have to start over with that at the EPA? Daren, I think we have you on mute. There we go. Go ahead.
Yeah, I think, okay. Anyway, yes, I think it requires a complete rewrite. I think they're going to have to withdraw the rule. I don't see any way around that. The rule relies heavily on a significant nexus test, and realistically, they're going to have to withdraw it and then start again. And I know this isn't an answer to the question, but I just wanted to build off real quickly what Charles has said before about kind of this, what I think is a myth regarding the pollution. And there's a headline in a recent article talking about how this opinion is like a gift for polluting industries. That shows a complete misunderstanding of the case and the issues. And despite myths to the contrary, these cases they're not focused on bad people dumping toxic waste into pristine rivers. Instead, and as what Charles was saying, they're generally well-intentioned people trying to do normal things like a farmer plowing land or a family shifting dirt to build a dream home, like the Sacketts. And it's important to understand that pollution under the Clean Water Act is really broadly defined, and technically, as was said, could cover kicking sand in the water. And as we were saying, the wetlands cases deal with dredge and fill permits. In Sackett, the Supreme Court said this regarding the significant nexus test. And because the Clean Water Act can sweep broadly enough to criminalize mundane activities like moving dirt, this unchecked definition of waters in the United States means that a staggering array of landowners are at risk of criminal prosecution or onerous civil penalties. So, this opinion to me is not a gift to polluting industries. The opinion is a gift to property owners who simply want to use their land in reasonable ways without fear of unreasonable civil and criminal penalties. So I wanted to add that.
Jamie asks us from the audience if this matter is settled now, writing that it looks like the Biden administration wants to continue investigating how the DOJ or other federal resources, federal agencies might come into play. And I think this ties into a second question from David, who notes that Justice Thomas's opinion sought a more clear tie to navigability. And the question there would be, has the question about navigability been reserved? Do we expect that this is something that is now essentially settled law? I know it's brand new. We don't usually use that term settled law for something so fresh off the presses. Or is there still more to come? Is this a fight that is ongoing? Maybe we'll start with Charles on these pair of questions.
Yes, so I think the matter is certainly settled, as Daren mentioned, with regard to the Biden administration's rule, which it unthinkably put out earlier this year, because that rule is underpinned in every respect by the significant nexus test. So it's hard to see how that would survive judicial review. As to the broader question, this is a very significant decision. It's placed significant limitations on the agency's authority, and it's gone a very long way in restoring Congress's intent for the Clean Water Act. But I think it's possible. It's sort of a wait and see, but there is more to come. There's still this question of navigability. The Sacketts proposed a second step to their test, which got to this question of when a water, it's understood commonly, is of the United States. So that Commerce Clause question, tying it more directly to navigability. And I think that question is reserved. Another thing in terms of more to come is we really need to wait and see what EPA and the Army Corps do next. They're going to have to issue guidance. They're going to have to put out another rule. And it's very important to look very closely at whatever guidance or rule they put out to ensure that is faithful to what the Supreme Court has stated is the law in Sackett. Because, again, this goes back to what Daren said in its opening. So make no mistake, that they have a lot less to work with now. But I think if history, unfortunately, could tell us anything, it's that every time they get rebuked by the Supreme Court, they go back to the drawing board and they find some way to exploit a loophole to expand their authority. And we may see that in the approach they take to tributaries or other surface waters. We'll see, are they really regulating things that are relatively permanent, such they have water in them all year? Or are they going to try and exploit some sort of technical loophole about average rainfall and snow amount? I don't want to get too technical about it, but I think there is more to come, because we really do need to see what the Biden administration or what any future presidential administration does with this decision. And I think, unfortunately, if history tells us anything, that may require litigation to ensure that they are being faithful.
Tell me what happens. We've discussed a little bit about how under Section 402 and 404, there's dual parallel responsibilities for enforcement with the EPA and the Army Corps, depending on whether it's more like a river or a stream or bay. On the other hand, the wetlands go to the Army Corps. The Army Corps does something else. One might even say its core function. They build things. They put up levees. They build dams. They work right beside, if not on top of, waters, rivers, wetlands. Does the Army Corps need to get permits before it undertakes activity? And if so, who do they turn to? Do they just ask the guy down the hall, Army Corps 1 asks Army Corps 2, can I have a permit to do whatever I want? How does that work its way through the regulatory system?
I'll leave Charles let you answer that. It's a tricky one.
So I've never really closely investigated the Army Corps' infrastructure development programs, but they generally do. They do need to go through environmental review whenever the government does something like this under NEPA, under the Endangered Species Act, and under the Clean Water Act. And it's a closed question I've never really looked at. I've never had the opportunity to represent the Army Corps in a permitting dispute, but they do need to address these issues when they're constructing infrastructure. And that goes broadly to the question of the impact that the Clean Water Act and the broad approach to significant nexus test has had on both private and public infrastructure development.
If I could follow up on the question before on whether or not it's settled or whatever, I think it's way too early. And I agree with Charles that we'll have to see what they come up with as it relates to relatively. I think one of the questions is, what does ordinary presence of water mean? In the Rapanos opinion, Scalia was more explicit, I think, when it came to ephemeral and intermittent waters. I don't see the same type of language in the Sackett opinion. And I don't think that means that the majority, when they're setting up the test, were saying anything really differently than Rapanos. In many ways, the Sackett opinion is kind of a copy and paste from Rapanos, which is kind of what I hope they do. and they did. But I think it's going to be interesting to see what happens with intermittent waters. What does ordinary presence of water mean? If a water simply is flowing like intermittently for like 20 days, a year, is that the ordinary presence of water? Is it require something more? These are the types of things that I think are going to be important, and as will the question of what the Commerce Clause issues and being stretchy when it comes to the Commerce Clause. Basically, if somebody crosses a state line to go to a water to buy a hot dog at an interstate lake, does that constitute interstate commerce? I think these types of things I can see being problematic.
Tell me a little bit more about the case itself. Was this represented? I want to get into some nuts and bolts legal questions. So it looks like from my cue here, we've got a lot of lawyers paying attention to what you had to say. This was obviously a big case. A couple quick ones. Is this something that we're going to look back at and see as landmark? Does this case, is this one of the biggest cases of the term?
I might let Daren answer that one. I may have trouble being impartial on the particular question.
Daren, how big of a deal is this?
It's a huge deal. I mean, we've been waiting, probably decades for some clarity on it. The truth is, I don't know that we've really had any clear answer on what Waters United States has meant since the statute was passed. There's just been constant changes over time. And so certainly we've been waiting 20 something years there's just been constant overreach. So we now have some clarity. This case is like the plurality opinion in Rapanos, which is narrower than people are saying, oh, this is narrower than the Trump navigable water protections rule. Well, it is. The Trump rule actually was probably too broad. Now they had their limitations. The court had maybe a little more flexibility than the agency did at that point. So this is really important. It provides clarity. And one of the big problems, I can't overstate the vagueness problem enough, is that the Corps will kind of apply, when you have vagueness, they'll apply the definitions in a kind of an ad hoc way and arbitrarily. And the GAO did a study, and this was cited in Rapanos, where basically saying they do this intentionally to have the vague definition so they can just apply a definition the way they want to. Now that's not going to be easy for the Corps. So it's really important.
So it's important for property rights. It's important for clean water, the regulatory apparatus, these mechanisms that Charles outlined at the very top of our conversation for permitting. Charles, can you speak to just a moment about the ruling itself and the makeup of the court? I don't track the Supreme Court as closely as some, but I see two threads constantly showing up in my reading list. The first is that the court is horribly divided and can't agree on anything, and it's clearly a partisan shop for one team or the other team. And then I also see that the Chief Justice has been navigating a court over the last 10 years toward a record number of unanimous decisions, a record number of cases that show bigger than what one might expect from partisan appointments, these pluralities and majorities. Is this a case that speaks to a new wave of property rights appreciation among all members of the court?
Yeah, I think there are some things we can read into the makeup of the court and the particular split on reasoning here. So again, underscore, the judgment was unanimous, and all 9 justices determined that under any interpretation, whether that be the majority of the concurrence, the Sackett's property was not regulable, significant nexus test is illegal. Now, there was a disagreement. 4 justices, led by Justice Kavanaugh, concurred in the judgment only. And the difference was really over reasoning. They sort of took issue with this indistinguishability question. And they said, well, they sort of looked to this oblique reference to wetlands adjacent thereto in another section of the statute and said, well, we need to look at what is adjacent. So that their concern was, they thought, under their view of the statute, certain wetlands that might not be directly touching, but might be separated from something like a dune or a berm, some kind of flood control infrastructure, could still be regulated under this sort of broader approach to adjacency. Now, I think there are numerous reasons why that's not faithful to the text of the statute, but I think that's really important to note are the sort of separation of powers implications of this unanimous judgment and of the two decisions, in that both decisions, majority in the opinions, majority in the concurrence, they were preeminently focused on the text of the statute. The dispute wasn't really over which test more better serves kind of broad policy goals or who thinks that the agencies themselves are in the best position to assess these kind of policy questions. They were preeminently focused on the text of the statute and ensuring that the rule that they set forth was faithful to the text of the statute. And that's really, really significant. It does represent a real sea change in the approach the court is taking to these kind of statutory interpretation questions. I think just one thing, just compare Justice Kavanaugh's concurrence in Sackett side by side with Justice Kennedy's concurrence in Rapanos, and it's night and day. Rapanos' concurrence really focused on, not really on the text of the statute, but on, well, which better serves the kind of broad, amorphous sort of purpose of the Clean Water Act. Kavanaugh said he looked at the text of the statute, and that's really what he focused on. So I think that's a really important to note in terms of maybe the broader implications of the decision here.
Is it fair? I'm trying to paraphrase you, and I just want to make sure that I'm representing your idea correctly. I believe what you're saying is on this line of cases, the court demonstrated that they're more interested in interpreting the law as it's written and less interested in creating tests, establishing policy directions.
I think that's a great summary. And I think it also, going to a sort of at a broad level, it represents, I think, this idea that the role of the courts is to look at what Congress intended, and the best way to do that is to look to the text of the statute. So really, the court was unanimously focused on determining what did Congress mean, not what is the best way to go about this because the agency said so, which is represents a remarkable shift, the sort of approach to textualism, this explicit representation of the separation of powers between Congress as policymaker and executive branch agencies as executing and implementing the law. That's a really significant change, particularly in the line of sort of environmental cases, federal administrative law cases.
I'd like to see some more of that. I have another question here. It comes from Jason, who says, when I'm discussing this case with the media, I hear claims that this ruling suddenly leaves as much as half of the wetlands of the nation unprotected. Can you touch on the role of the states in protecting wetlands, streams, lakes, etc.? This is something we've alluded to a couple different times, but I really would like to get into this question about the multi-layer or the concentric circles, if you will, of how we regulate and protect waters and lands. Could one of you signal that you'd like to jump on Jason's questions here? Could you touch on the role of the states?
Sure. I mean, first of all, I think one of the problems, again, with percentage decreases, increases, whatever, is we don't really have a good idea of what the baseline really is. How do we even figure out the wetlands and where are we starting from? But let's just say, for the sake of argument, that that's true. I mean, again, the states can fill in those gaps. One of the key points is that the federal government is not supposed to be intruding on what is traditional state power. This is also a key theme that was brought up in this case, and also many years ago in the Rapanos opinion, is that there was a concern that the federal government was encroaching on the state's traditional power. Things like wetlands issues, those are traditional state powers. They're encroaching on that. There may not be a magic bright line where the federal government, this is the waters federal government should regulate, and here's what the state should regulate. But there's no question that to respect the will of Congress and the statute, the federal government was expected to play a relatively small role, and the state would be playing a much greater role. So there shouldn't be an assumption that because the federal government's not playing this huge role to cover these wetlands, that somehow the wetlands are not going to be protected. So I would just say that it's a myth. There's just an unfortunate assumption that the federal government is needed to protect things. I disagree. There's plenty of ways to protect wetlands if they're needed to be protected, and it doesn't require federal regulation.
And it would seem to me, I don't have the figure at my fingertips, but it would seem to me that this sort of assertion that as much as half of the wetlands would somehow become unprotected absent the federal government, it's missing a big swath of wetlands in America that are privately protected. The Audubon Society, the hunters organizations, all sorts of state level parks and recreations, preservation systems. Charles, let me ask you, the state of Idaho, were they constructive? Did they help? I mean, this case went on forever. The Sacketts are without their home. They're citizens of Idaho. And here we had a very clear rebuke from the Supreme Court to the federal agency saying you went too far. Did the state of Idaho help vindicate the rights of the Sacketts and other landowners?
Yes, so the state of Idaho has been involved in litigation over this WOTUS issue. In fact, going back to that 2023 Biden rule, the unthinkable 2023 Biden rule, the state of Idaho was actually one of the litigants to get the first preliminary injunction against that rule in Texas. Idaho has also joined a amicus brief. So it goes to show the states themselves, they're invested in this, right? They understand this. Really, this goes to the division of power between the federal government and the states. The states have their own regulatory programs. The states have police powers, residuary powers under the Constitution to regulate land and water use. The Clean Water Act even recognizes that, but the federal government has been using the Clean Water Act to really usurp that role of the states and essentially create them to themselves a federal land use or zoning board. And going to that question about leaving wetlands unprotected, this ties into that. I think there's an assumption underpinning that, which is incorrect, which Daren goes to. And I think a really good point to make is the Sackett decision, it's sort of agnostic on this broader question of whether or not, as a matter of policy, wetlands should be protected. What it does is it brings discipline to who is regulating those wetlands. It recognizes Clean Water Act gives these federal agencies limited authority to regulate certain wetlands. The rest is left to the states to exercise their discretion. And that's really the way things should be. State governments are much closer to the people, they're accountable, and they are in a much better position to assess the trade-offs between environmental protection and development at the local level.
I could just add that, Kent, your point is great. I mean, protected, does that mean that if it's not unprotected means that the government's not protecting it, therefore it's not protected? So I think that's a key point that you brought up. And also, protected from what? Just if you're moving some dirt around, is that somehow really devastating the wetlands? So, that I did want to actually disagree slightly. So add some drama here, have an argument. I do think that with the Kavanaugh opinion, I do agree that there's a focus on the statutory language, but I do think that Kavanaugh was a little bit worried about more of making a policy argument that some waters may not be protected. So I do think that there's a little bit of a concern there by Kavanaugh, which was unfortunate. That's not a legal issue. That's a policy question. And that wasn't really, which I think was a weakness of his concurrence. I don't know, Charles, what you think about that.
No, I agree. I think the important thing to note about the Kavanaugh concurrence is the focus, the kind of legal rule that he sets forth, a focus on the text is sort of preeminent there. I'd say a misguided focus on the text. He focuses on this question of adjacency. But I agree, there are certain concerns. I think that's a win in and of itself. But I do think you're correct that Kavanaugh does use some kind of broader concerns, policy concerns. Now, nowhere near to the extent that say Kennedy did in his Rapanos concurrence, but he does kind of buttress his ultimate legal conclusion by thinking about or by pointing to his view that a narrow wetlands test would undermine the role of the agencies in protecting certain features. But I do think it's important to note, I mean, it's a small win that the concurrence here and the concurrent justices, they did go to the text first before they even went there. I mean, often that relationship is sort of inverted. What we've seen in these environmental decisions over the years is they start with policy and sort of work back to the text from there.
Daren, let me ask you, as we're coming up on the top of the hour, as you look into your crystal ball, you look forward a little bit, what are the implications of this ruling in Sackett v. EPA for the agencies, for the Army Corps and for the EPA? I think that is the target of your work, and it's something that'll help people anticipate what's coming next.
Well, I think in the short term, the implication is they need to withdraw the rule. They need to issue some type of guidance. I think something interim needs to happen. And then they need to develop a rule that's consistent with the opinion. And I think, look, at some point when you're overreaching for 30 something years or however long it's been, maybe actually don't do so and actually try to keep it consistent with what Congress wanted and what the court's telling you. Then maybe we can kind of avoid these issues. So that's what I think means for the agencies, at least. And for Congress, I think they need to engage in some oversight. So that's what I would focus on if I was Congress.
And Charles, last question for you. As you wrap up sprint the last couple of weeks explaining what happened, you spent all these years working on a case, and then you just have a lot of attention. People want to know what it all means. What do you expect? What happens next? And how should we frame this in our minds as we walk away from our conversation today?
Yeah, so I think this is a significant win for property rights and for the separation of powers. It really is an incredibly important decision. I think we didn't get quite into this, but looking to some of the sort of reasoning in the majority's opinion, there are broader separation of powers implications. There was a strong focus on this kind of federalism clear statement rule. Another thing that sort of touches on what Daren noted, in terms of the vagueness of the significant nexus test and the fact you can't just sit, the government doesn't get a blank check to send people to prison. There's a very, very clear recitation of this principle in the Sackett majority. This idea that penal statutes must be construed narrowly against the government. And it's probably the clearest statement I've seen in the context of a regulatory statute. And I think that'll reverberate beyond the Clean Water Act. I think there are many other federal regulatory regimes where the government pretty much considers itself to have a blank check to go after people, send them to federal prison, fine them. And the court here in Sackett noted that that's unacceptable. That's not how the law should work in a liberal democracy. So I think we'll also see some of those implications in other disputes over the role of the federal government and the power that the federal government has. In terms of what's next, I think we really, in terms of the Clean Water Act, we need to see what the administration does, what sort of guidance they issue, what their new rule does, and we need to go from there. But I will finish by saying one thing. It's really very, very important. The agencies cannot use this as an excuse. The difficulties they're now experiencing as a result of their approach being struck down are of their own making, and they cannot use this as an excuse to jam up their own regulatory programs. They need to begin issuing approved jurisdictional determinations, and they need to begin issuing permits under the new Sackett rule, and they need to do that quickly. They cannot take this as an excuse to continue victimizing property owners and those attempting to use their land productively.
I want to thank you both. We covered a lot of material here. This was a big case. Charles Yates, you're at the Pacific Legal Foundation, seated there in Sacramento, the headquarters, but you have offices all across the country doing great work in public interest law. For those of you watching and would like to know more about the organization and their cases, you can find it at pacificlegal.org. Charles, I look forward to working with you in the future. Daren, thank you so much for joining and helping me work through the implications of this case for the WOTUS rule and the next WOTUS rule, and probably the WOTUS rule that comes after that when the EPA can't help itself but go too far. We've been enjoying this conversation, which is live, but it can be found online as soon as later today. It'll be at cei.org under events with all of our event programming. I'm going to remind each of our audience members to help us out with just a quick 30-45 second survey that will pop up on your screen as we close. With that, I'm Kent Lassman. I thank you both very much, and I look forward to talking to you again soon.